I'm Cynthia Rowland, and this is episode 42 of EO Radio Show. Today's episode focuses on documenting decisions made at meetings of the board of directors or trustees of a nonprofit organization. While everyone who attends a board meeting should keep their own notes, and those notes can follow any style and can focus on the recording person's understanding of what transpired, it is the meeting minutes, as ultimately approved by the board, that serve as the legal record of the decisions of the governing body. Since the members of the governing body have the fiduciary responsibility for the organization, the decisions described in the minutes should be carefully drafted. In this episode, I'll cover the basics for the person charged with the responsibility of drafting the minutes, touching on what should be included in the minutes and what can be left out. Welcome to the EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. In this episode, I am talking about the requirements for documenting board decisions in meeting minutes. A few notes for context, though. These suggestions I'm going to talk about today do not cover critical issues that need to be considered by nonprofits that are subject to open meeting requirements or special rules that apply to government-funded organizations. My focus today is on the small organization with a relatively small board of directors that ordinarily operates pretty much by consensus in a relatively informal manner. Organizations that have voting members or very large boards will have other considerations to keep in mind. In that regard, I'm not going to address Robert's Rules of Order, which should be an episode of its own, and those rules do make good sense for meetings with many, many participants. But they really aren't appropriate or even necessary for a board with a relatively small number of members. Once the board size starts to exceed, say, a dozen active voting members, more formal rules start to become necessary. But for the small board, I've found over the years that attention to the basics I discussed today will be helpful, and a deep knowledge of parliamentary procedures of Robert's Rules of Order isn't necessary. So let's dive into this by focusing for a moment on the purpose of the minutes and how they will be used. Once approved by the board, the written minutes serve as the official legal record of decisions made by the fiduciary board. This means that the decision makers can in the future be held accountable for the decision if it has unintended negative consequences, and conversely, it can protect those who voted against a particular decision that turns out to be ill-advised. While we aren't going to go into fiduciary duties specifically here, the main point to keep in mind is that the minutes serve as the official record, so they are important for establishing that the board members have used good judgment in reaching their decisions. Another basic point to keep in mind when thinking about the minutes is that the drafter should have a basic understanding of the bylaws or other governance document that describes the decision-making requirements, such as how directors are appointed, their terms of office, meeting notice requirements, the quorum required for decisions, and whether supermajority votes are required or certain classes of directors must be in attendance to approve certain actions. Some bylaws include specific reserved powers in other organizations or designate certain individuals as decision makers on specific items. And so the drafter of the minutes should be aware of those things so that the minutes don't overreach in describing a board action that's not authorized. Of course, the chair of the meeting should be knowledgeable about these matters, as should the board members themselves. But it is also important that the person drafting the minutes should keep those requirements in mind so that the minutes can reference any special rules that are specific to the valid approval of actions presented to the board. There are many different formats for meeting minutes that can work, and samples are readily available and will pop up in any online search. There isn't a magic formula. I draft minutes for many different organizations with many different styles, and it's fine to be respectful of what is comfortable for the specific group of directors. It is always helpful if the chair of the meeting has presented a specific agenda and the board members have been provided with appropriate board materials in advance to support their consideration of the agenda items presented. While it is not necessary to record everything that the directors say at a board meeting, some things should always be recorded. Here's a list of many of those common things that need to be in the minutes. The date and time of the meeting, that is, the time that it was called to order and the time that it adjourned. The minutes should record whether the persons in attendance were there in person, by audio only, or by video conference. The minutes should record whether notice was given or whether the directors waived proper notice for that particular meeting. It's often obvious, but it is important for a special or emergency board meeting to record whether proper notice was given, and if not, to make sure that waivers of the notice are obtained after the meeting. The minutes should name the directors who were in attendance and the directors who were not. The minutes should list the names of other guests and staff members in attendance. The minutes should state whether there was a quorum at the beginning of the meeting and whether the quorum was lost at any particular point. And in that regard, the minutes should note whether any directors left the meeting early and returned. Some additional items that need to be included in the minutes are a discussion of any alternatives considered for important decisions, a clear description of the board decisions actually made, a summary of key points in the meeting materials, or oftentimes nowadays it's easier to just reference the board materials rather than trying to provide a synopsis in the minutes. The meeting minutes should also describe whether any board members recused themselves from a discussion, which often happens in the context of insider transactions. So it's important to note whether someone has recused themselves and left the room for a discussion where they might have a financial interest. And similarly, it's important to note whether a board member has abstained from voting. Finally, if a resolution is not approved unanimously, it is very important to state which directors voted for and which voted against a particular resolution. Meeting minutes should also describe any resolutions taken that direct or authorize staff members to take particular actions and the breadth of their authority, whether they need to check in with anyone or whether they are charged with, say, closing a transaction or approving final documents. So let's recap with some best practices for nonprofit meeting minutes. As noted above, the minutes of the meeting should track who was present, excused, and absent from the meeting. Some bylaws actually provide for automatic removal if a director misses a number of meetings, so it's really important to keep track of who's there. Another best practice is to provide a clear description about board votes and actions taken. It's not necessary for the minutes to include a transcript of everything said at the meeting, and in fact, taking a transcribed approach to the minutes can chill frank conversation about difficult topics. It is important to draft and distribute the meeting minutes to the directors soon after the meeting. This will help the board members to catch mistakes or to correct misleading phrases or references that were unintended. Finally, it's important to maintain a sound document management system so that minutes are not lost or misplaced and unable to be found when needed, which typically comes up at the end of the year when the auditors ask for meeting minutes. So good practices can go a long way in making that a smoother process. So that's the best practices for the minutes in general. Let's talk just a little bit about resolutions, drafting resolutions. A resolution is a specific description of an action approved by the board of directors that approves a particular action or describes the position to be taken, policy to be adopted, or contract or other agreement that is approved and authorized. If a resolution conflicts with a bylaw or other governing documents, the bylaw prevails unless that particular governing document is amended or repealed. So here are 5 types of actions often documented in formal board resolutions. Number 1, the matter is one that the articles or bylaws or trust instrument requires to be covered by a formal board resolution, such as the election of directors. Number 2, delegations of authority to staff or committees to act or direct an activity or pursue a particular path. Number 3, resolutions directed by a third party. For example, a bank, investment manager, title company, purchaser or seller of assets may require a specific resolution to be approved by the board. Number 4, resolutions approving policies and procedures that govern the management of the organization that is intended to be permanent until changed by the board. And number 5, any amendments to the articles of incorporation or bylaws. Resolutions that involve technical legal matters or approval of third-party transactions usually should be drafted or at least reviewed by legal counsel. It is also a common practice to provide a copy of the resolution to the leadership of the organization before the meeting to iron out any nuances that need to be addressed. There are a number of related topics that are important to coherent board meetings and minutes, and these include developing an appropriate agenda, what to include in the board materials and what not to include, when to take action by unanimous written consent, when to move into executive session and excuse guests and staff members, and similar good business practices. Let's save those for another day. But do take a look at the show notes for links to prior episodes on bylaws and governance matters in general. So that's all for this episode. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.